appeals are heard in the matter of Hussain and GA Ethiopia and Secretary of State for the Home Department.
Yes, good morning.
Good morning, my Lord. Well, just, if I may, just in terms of timings, I'm going to do my very utmost to finish my submissions by 11:15. As I said earlier, I'm happy to shave that extra time off my reply this afternoon.
That's fine, just keep going.
I'm grateful. Just in answer to my lady's query overnight, I've, as far as can be ascertained like that, there's no indication in any of the papers that I've seen or in any of the material that there was any correspondence that we haven't seen or that isn't reflected in the judge's determination itself. So there's no communication between the parties and the judge after the promulgation of the determination, apart from the application for permission to appeal.
Thank you very much. Thank you for that clarification.
Grateful. Two other points, my Lord. My learned friend, Ms. Kilroy, has handed up a document this morning, which will be sent electronically, I understand. That's just some references to EPR Albania, which may assist the court. I'm not going to refer to it, but she may do in reply. Yesterday afternoon, I was about to look at the substance of the 2nd of April submissions, having attempted to establish the judge did not have them in mind at any part of the substantive analysis of his decision. Just to look at what's in those submissions. This is obviously with the caveat of what I said yesterday about the nature of that document. And I'll just spend 10 minutes or so, if I may, just looking at what's in it and the structure of it. It's at tab 10, page 73.
Of the core bundle.
The core bundle, yes. So paragraph 1 of the submissions themselves reflects and notes that the submissions are in accordance with the directions. And those directions obviously were specifically aimed at giving the appellant further opportunity to elaborate on the grounds of appeal by way of a substitution for the sorts of exchanges that might happen in oral hearings. So it was the purpose of the directions was in order to mitigate any disadvantage from not having that second opportunity to address the grounds. The submissions go on at paragraph 4, and the paragraph 4 of the grounds, the submissions, make the point about the need for a reflexive engagement and reiterate what's said at paragraph 3, that some form of hearing is required. There is then at paragraph 7, and this is the point model I mentioned yesterday, what counsel says these grounds are for. They're described as the grounds of appeal rationalised, and they say the grounds of appeal which secure the permission are not expressed with concision or precision, although they continue to be relied upon. And then the grounds are essentially distilled, if that's the right word, it probably isn't, they are set out in 7 separate paragraphs. And I'm not, obviously given the time, I'm not going to go through every single part of these submissions which differs from the grounds of appeal or the later reply. But I did just want to highlight 3 points, if I may. The first is paragraph 7.1, so that's on page 74. Now this is the argument about the timing of dependency. So there's authority on the point that one needs to show that one was dependent immediately before departure from the country of origin to the UK. And this ground argues that the judge did not have that submission in mind and therefore did not approach the case on the basis of the correct temporal limitation on when dependency needed to be shown. In the 2nd of April submissions, what council does is take that ground, which the grounds of appeal. But it highlights his point with a direct reference to the judge's reasoning at paragraph 8, and you'll see that on page 75 at the top. For the substance and materiality of this ground, see the determination as a whole. Note, for example, paragraph 8, where the first-tier tribunal judge appears to criticise the appellant for not providing documentary evidence covering the period he resided in Pakistan with or without his sponsor. It takes the ground, it directs the judge's attention to a part of the determination which counsel says supports the ground. It's precisely the sort of thing one would endeavour to do in a normal hearing. If one goes back to the grounds, which are at tab 13, page 88, and that particular part of the submission to the second of April reflects paragraphs 26 and 28 of the original grounds, page 94 and 95. And you'll see, I hope, my lord, that paragraph 26 sets out the authority on the point about the temporal limitation of privacy.
That's an accurate statement of the law, but his case was, I was dependent throughout by living in a household supported by my uncle. So yes, you can make that as a legal criticism, but it went nowhere on the facts of this case, given what his evidence had been, which was always supported by uncle.
Well, yes, although if the judge was looking at the case on the basis that he needed to show that he was supported by the uncle throughout that period, then that would be a misdirection, because he could succeed on the basis that she wasn't satisfied that he was supported for all the period apart from, say, the 3 months before he arrived. And there was evidence, submissions directed to that on the basis that that was the period in which his some of the money transfers were made, and also the fees were paid. So I take my lord's point, but it's one of those cases where he can succeed even if only part of his evidence is accepted. So after stating the law on paragraph 26, there's then the core of the ground, paragraphs 27, 28, just simply makes the point about timing and then refers to some of the evidence. Doesn't have the direction to the determination that the 2nd of April submissions have. There's also another document, my lord, the reply, which I ought to deal with briefly. That's the 16th of April 2020 reply at page 51 of the bundle. And you'll see, again, I won't dwell on this, but at paragraphs 36, 43 and 45, there is reference to the same ground.
Could you give me those again?
Yes, paragraphs 36,
Thank you.
43 and 55. The underlying ground is referenced, but again, the direction to the part of the determination that's said to support that ground is not there. Then the second of the illustrations of the 2nd of April's submission, so back to tab 10, if I may, page 73, so going to paragraph 72b, which is page 75. Sorry, page 76, I should say. This was to do with what's described as the Habib bank receipts. And you'll, again, given the limits of time, I won't go through it all, but one can see from 7b there is a significant amount of submissions under that point, cross-referencing to possible interpretations of the evidence and possible reasons the judge may have had for not treating them as taking the case much further. That goes over the page to page 77. The grounds of appeal, that reflects the grounds of appeal at paragraph 21. And that's a much shorter version of that, essentially making the short without the illustration and the amplifying of the argument that one sees in the 2nd of April, 2nd of April submissions. And then in the reply at paragraph 14, what the reply does on this point is refer back. This is at page 53. And this is quite illustrative in my submission of the way the submission is structured as a whole. So tab 7, page 53, paragraph 14. The appellant has explained in detail at paragraph 7.2b of his submissions, and throughout this document, the submissions are described the 18th of March. That's either an error or in some way referring to the fact that the submissions were triggered by the direction of the 18th of March, but they're not really not dated 18th of March. That the FTJ failed to provide legally adequate reasons for asserting that the do not take matters further. There's a very brief summary in paragraph 14 about what's said at paragraph 7.2b, but not the detail. And then the appellant goes on to deal with the points made by the respondent in that regard. So taking the three documents as a whole, the grounds of appeal, the 2nd of April submissions, and the reply, one can see that part of the forensic argument is lost if one doesn't look at the 2nd of April submissions. And then finally on this point, at paragraph 7.5 of the 2nd of April submissions, again back to tab 10. This is at page 78. This is the point which I'll come back to in another context, about the question of whether or not the ledger that was produced as evidence was a contemporaneous document, so a ledger in the true sense of the word. And again, there is a detailed submission in the paragraph 7.5, including the footnote 8 at the bottom of the page, which makes two main points. One, it points to the specific entries in the bundle, and this is the point where it goes further than the grounds of appeal, as we'll see. There is an explanation put forward as to why some confusion may have arisen about the two sets of documents. So that's a point, as I'll come to, which is unique to this document. Going back to the grounds, this is dealt with at paragraph 24, which is page 93. And I didn't go through the whole paragraph, but the short point is it's not that additional explanation, additional direction of the judge's mind to specific evidence is not within that paragraph. Neither is it, and I won't turn out, I'll give you the reference, it's paragraphs 34 to 36 of the reply document. Again, it's raised, but there's not the specific piece of advocacy that relates to the evidence and the explanation. So those are the three examples. There are more in my submission, but they're the three main examples I would pick to illustrate that there was substance in the 2nd of April submissions. As I said, that's all caveated with the proposition I put yesterday, which even if I couldn't do that, I would still be submitting that there was a procedural irregularity sufficient to render the judge's determination unsafe. I think one last point on this, on the reply, again back to tab 7, page 51. Throughout that document, there are references back to what's described as the 18th of March submissions, but they are the 2nd of April submissions. I'll just give you those references, please. They are at paragraphs 4, 12, 14, 16, 18, 19, 21, 24, 30, 33, 34, 42, and 49. Now, of those references, 6 of them specifically refer the reader back to the document in order to say, as set out in, and then build on what the reader, the writer assumes the reader will already have read, if that makes sense.
They refer expressly back to the 2nd of April.
Yes, so they say, as said here, this is why it matters. So so for example, perhaps an example so doing it at paragraph 14 of the reply, which is at page 53, tab 7. What's said there is the appellant has explained in detail at paragraph 7.2b of his submissions of the 18th of March that the FTJ failed to provide legally adequate reasons for asserting that he banks do not take matters. There's then a brief summary of what's said in those submissions, and then the argument is built. So the idea of the structure of the three sets of submissions, grounds of appeal, 2nd of April submissions, and then the submissions in reply, which are oral and specifically a reply to respondents'
Sorry,
comments.
the reference I'm looking to, paragraph 4, was that the example you were giving?
14.
14, I'm sorry.
14. So they refer to them as the submissions of the 18th of March.
Yes, as I've said, I think that's either simply an error or it's a reference. Well, it is an error on anything. It might be that what council had in mind is that the directions of the 18th of March triggered those submissions, but I accept it's not accurate. The other examples of that sort of reference back is at 18, 19, 24, 34 and 49, so specifically where those submissions build on or refer the reader back to the previous written submissions. That reply concludes at paragraph 49, page 61, with a reference to the foregoing, which presumably is that reply, the 18th of March submissions, which we know are the 2nd of April submissions, and the grounds of appeal. So it concludes by asking for the three documents to be taken into account. Those are my submissions on the question of really the individual procedural irregularity in this case with regard to the failure to take into account the 2nd of April submissions. There's a ground 3 of the grounds is a specific criticism of failure to engage with a number of the underlying arguments in the case itself, irrespective of the 2nd of April submissions. I'm not going to go through each of the examples. They are in a table at the back of my skeleton, so the references are there. There's one that is particularly illustrative in my submission, and that's the argument that is at paragraph 7.5 of the 2nd of April submission. Again, back to tab 10, page 78, sorry. And this is the question of whether the ledger that was put forward as an example of, firstly, payments going to the household from the UK, but also how they were spent, whether that was a contemporaneous document. And if it wasn't a ledger in any sense of the word. So it's quite an important aspect of the judge's decision because it has certain consequences. If the first tier judge wasn't satisfied that a document put forward as a contemporaneous ledger was not in fact contemporaneous, that was a very significant finding because clearly the alternative is that it's in some way put up job. One can imagine all sorts of examples in other jurisdictions where someone puts forward a contemporaneous document but the judge thinks this isn't actually what it says it is. So this was a key finding. It was a key part of the argument before the upper tribunal in my submission that the judge hadn't given sufficiently adequate reasons for that finding. You'll see at page 78, paragraph 5, the second paragraph, there's two paragraphs under number 5. In particular, that without prejudice, the first tier tribunal judge's assertion of paragraph 42 of the determination that the said document was not contemporaneous was reversed and or was inadequately reasoned. The ledger excerpts certainly appear to be, would be expected to be, given the nature of the ledger, contemporaneously produced. Against that background, the FTJ's reasoning is unsustainable. And then there's the footnote with the detail where the judge is directed to look at or asked to look at the bundle. The short point here is, and I touched on it yesterday when I went through the structure of the Upper Tribunal Judge's decision, this is that he misses out of transposing the grounds of appeal into his decision. He doesn't deal at all with the question of whether or not the judge's finding that the ledger was not contemporaneous was fraud. It just doesn't engage with that. And that is one of the three examples that I've given in my skeleton as to, and also reflected in the original grounds of this court, as to why there was a substantive error of law as well as...
Could you just give the references to the FTT judgment and the Upper Tribunal judgment when they deal with the ledger?
Yeah, so
because there are a number of things which might qualify as ledger.
Yeah, so the FTJ's point is at paragraph 42 of her decision, and that's in the bundle, at the core bundle at page 98.
Yeah.
So that's the paragraph 42. She says there is a handwritten document said to be a translation of accounts and notes from inserts from the diary, presumably the uncle. It does not appear to be a contemporaneous document.
What, the translation?
Well, so that's an interesting point my Lord raises, because that's the footnote 8 to paragraph 7.5 of the 2nd of April submissions. Because what's said there is one of the problems may have been that the judge was confusing two things, and so that's where the 2nd of April submissions. That's the only place that point is made in the pleadings.
But she's not saying this was a fraud. What she's saying is I don't attach much weight to it because given the expenditure which we know was going on, including payment of school fees, etc., not enough was being transferred, and therefore she says I don't attach much weight to it. Now, you and I might have given more weight to it, but it's not a legal error not to attach much weight when you've given a proper explanation for it.
I suppose there's 2 points arising from that, my Lord, if I may. The first is
of course.
The first is that she says it's not this does not appear to be a contemporaneous document. Now, what that means, and the points made in the grounds, is that is firstly, it's not entirely clear what she means by that, and there's some suggestions made in the submission. But secondly, it's a potential point. It's a point that has at least some potential forensic weight that just isn't dealt with. So it's one thing to say, well, there may be other reasons in the determination what that could be sustainable, but the Upper Tribunal just don't do that. The Upper Tribunal judge does not say, well, the judge could have expressed herself more clearly as to whether this is a contemporaneous document or precisely what she meant.
Where's the Upper Tribunal judge deal with it?
So the Upper Tribunal judge, in his... so that's at... that's at tab 6.
Is it paragraph 34? Or?
Yeah, so I made the point yesterday that the paragraphs 20 through 25 of the judge's determination essentially transpose the grounds of appeal, missing out the paragraph that deals with the contemporaneous ledger. The ledger is dealt with, well, the decision as to whether there is an error runs from paragraph 17. You'll see a reference to the submission of paragraph 21. The appellant also claims he provided his uncle, actually uncles in Pakistan's contemporaneous diary, which he kept a detailed log of the support sent by the sponsor of the families. And then later in the judgment one can see from paragraphs 34 through to 42, simply to say that there isn't, at that point is not engaged. The contemporaneous point, or indeed the wider points, are not engaged with.
34, you say?
it's paragraph 34 through 42 that the bulk of the judge's reasoning.
Well, it's paragraph 38. The judge specifically considers the diary at paragraph 42. And says it's supported by adequate reasoning.
Yes.
And what's wrong with that?
Well, because it doesn't engage with one of the central points, which was that the judge was wrong to approach that evidence on the basis that it wasn't contemporaneous, which obviously did, even if it's not a fair inference to suggest that meant she had doubts about its credibility or veracity. It's a very significant finding to make about a document that is put forward as a ledger.
But he says it's important to read the decision as a whole to understand the judge's concerns.
Yes, but I mean, that doesn't take matters much further, particularly when I've already made the point yesterday that there's no indication in this document that the judge has actually seen the arguments put as to why the judge's determination as a whole is not an adequate reflection, or is not adequately reasoned if one looks at the individual criticism. So this is, in the context of this, of course, is the argument about the 2nd of April submissions, followed by the argument about individual grounds of appeal not being engaged with in the context of there not having been a normal hearing. Well, I see the time, so I need to, if I may, to move on to the next couple of points. I did want to make brief reference to some of the learning in this area. I suspect some may well be trite, but just in terms of what amounts to an error of law when a judge doesn't engage with a particular argument. The first reference is in tab 45 of the authority bundle. It's R Iran at 1106. Paragraph 9. Simply essentially a list of sorts of errors of law which are frequently encountered, and it's the second and third of those: failing to give reasons or inadequate reasons for findings on material matters, or 3, failing to take into account and or resolve conflicts of fact or opinion on material matters. That's also reflected in the reasoning in MK Iran, which was a decision of the ex-president of the tribunal, Mr. Justice Kikoski, as he then was, regarding the, again I won't go through it, but it's a useful summary in my submission as to both the sort of historical cases on the point, but also their application in the immigration arena. It transverses also the reason why failure to engage with arguments and failure to give adequate reasons is a function of the fairness jurisdiction. And the short point there is that where you have here a concern about the fairness of procedure generally, so a concern as to whether an argument has, or set of submissions actually have been taken into account. That is an unfairness piled upon an unfairness where there isn't an engagement with a particular ground. And so I won't transverse all of that authority, but there is in my submission a very accurate and useful summary of the points in MK, which is a short judgment in any event. I just want to deal with the last 5 minutes with the question of the failure to hold an oral hearing. And I'll make a specific point. I've specifically adopted my learned friend's submissions on the generality, but I'll make a specific point with regard to my case and the reasoning of the judge. And it's this, is that for a very many number of years, the upper tribunal procedure rules have defined hearing as either a face-to-face hearing or by some other mode of technology, so specifically telephone or video. And all the way through the submissions in this case, from the grounds of appeal, from the 2nd of April submissions through the 9th of April to the 16th of April submissions, the appellant was saying, if the current situation means I can't have a face-to-face hearing, the proportionate response is to have some form of hearing by telephone and video. That is a course of action he asks for again and again. In the President's response to ILPA, which we looked at yesterday, which is in the final tab of the core bundle, I need to turn it up. But the President says that the process that the upper tribunal were going through at the time was to first of all decide whether there should be a hearing. And then, if they conclude there ought to be a hearing, then decide whether it can be made by video. My submission is that that's wrong in principle. That what ought to have been done is decide whether or not any concerns, any of the difficulties with regard to the lack of oral hearing could be assuaged by some proportionate response in the individual case. Now, what I say about that is that in this case, there were specific submissions made that if face-to-face hearings couldn't be held in this case, can we have a video hearing? Can we have a telephone hearing?
I mean, I completely understand that, but I don't understand the wrong in principle to say the first question is, should there be a hearing? I mean, isn't that the first question?
Well, the first question, well, it depends what's, I suppose I should put it another way. The first question should be, is it possible to have some form of video hearing or telephone hearing without causing...
Well, it obviously is. I mean, that's not a question. I mean, from the very first days of COVID, all the courts and tribunals started doing, as is in your various submissions,
yes,
started doing remote hearings if they hadn't been doing them for years anyway. So that's not a question. Of course, they could have a remote hearing. You possibly, at that very dark stage of lockdown, could not have a face-to-face. So, I mean, surely the first question is, does there need to be a hearing?
Yes, and I think the way I put it in my individual case is that one takes the procedure as a whole. So from the beginning through to the end of the procedure, the judge at any stage could either have engaged with the request for a video or telephone hearing, or decided that the difficulties that were emerging, shall we say, with the documents and the submissions, could be solved by having a fairly proportionate response, which would be to have some form.
I mean, you know, I would say it's absolutely obvious, and it's something that I was heavily involved in, I won't say directing, but certainly involved in deciding in the courts. The first question is, does there need to be a hearing? The second question is, can there be a hearing during COVID? And that depends on whether the hearing has to be in person, which in some cases it did have to be, which necessitated adjournments, or can the hearing be done remotely? And people's views about the efficacy of remote hearings changed dramatically in the 2 months following the 20th of March. But, you know, that's all sort of by the by. The process of reasoning is the one I've described, which seems to me to be absolutely unanswerable.
If I put it another way, then, my lord,
I mean, your point is the point you make about the request for a remote hearing is a very important one, because in your case, your client was very pragmatic and said, I see, we've got COVID and I can't come in, I can't expect judges to come in and hear me in person, but I do want a hearing, and I'm happy with a remote hearing. Well, that was perfectly reasonable. The question is only whether the decision not to allow him one was made on the right basis.
My lord, yes. And the last point I'll make on that is simply that the possibility of that is nowhere reflected in the judge's reasonings for not having an oral hearing.
What was the date of the reasoning?
That comes on the, well, it's 18th of May is the final
Well,
decision.
by then everybody knew you could have one. I mean,
You could.
have a remote hearing. I mean, it wasn't outlandish by the 18th of May. On the 18th of March, it might have been thought to be unusual.
Yes, but the point is that the judge having, so the appellant quite reasonably says, I'd like to be able to expand my argument. I'd like to have the reflexive engagement.
Sure. Well, reflexive means nothing. I mean, reflexive is the wrong word, and I was going to raise it earlier. It's an irritating. It's an irritating malapropism. But anyway, I suppose it means could mean reflective. But I don't even think that's a word for this. It means it just engagement. Let's leave the adjectives out.
It's not my fault.
No, Mr. Lee, far be it from me to be blaming you.
But I just want to attempt to make this point good. That the point about that is that there was a middle way.
No, I mean,
It isn't
completely
reflected.
get that. Well, I completely get
Yes,
that.
It's not reflected in the judge's decision.
No,
And in
no,
all
no,
of these, given all of the points my learned friend made, all the points that made in JCWI about the central place that all argument has in the tradition, and all the points that have been made for many, many years about how useful it is to be able to do that, there was a proportionate response open to the judge, which he doesn't engage with and doesn't give reasons for. So,
Well, we've definitely heard from Ms. Kilroy the authorities for the proposition that oral argument is very important. But of course, that has to be balanced against situations where it's difficult to arrange, and also situations where it happens not to be that important, which might be in questions of pure law.
yes,
Many courts in the world manage very well without any real oral argument. But I understand the point. In our tradition, it's certainly something we've relied upon for centuries.
and if one takes the approach that there's balance in all things, there was a balance between a face-to-face hearing and no hearing at all, and that balance would be to have a remote hearing, and that's a perfect proposition.
I mean, absolutely. In that situation, at that time, a hearing meant a remote hearing, actually, because you couldn't get people in. It was dangerous.
And by the 18th of May, everybody knew that there was no magic to it. It was perfectly simple, straightforward to arrange.
Yeah,
It was possible to make coherent submissions. It was exotic.
It was exotic on the 18th of March.
It was.
Very non-exotic on the 18th of May.
And so, the short point is, it was an option that simply hasn't been engaged with.
Completely agree. Yeah.
Unless
Thank you, Mr. Lee. No, thank you very much. Yes, Mr. Waite. I think I called you Mr. White yesterday, for which I apologise profusely.
If I may, I will address the court with reference to 9 issues. I'm just going to set them out now.
So you're going to have to keep your voice up a bit.
Sorry, yes. My lord, 9
Otherwise
issues.
I shall move you to the next bench.
Yes. 9 issues. Number 1. What is the legal test which an upper tribunal judge, UTJ, should apply in deciding to determine an appeal without a hearing? Issue 2. What is the test which should be applied by this court in deciding whether the UTJ has erred in law in deciding to determine the case of the papers?
You're going too fast for me to get these down.
Yes.
Do you want to just go through them and we won't try and get them down, or do you want to go slow enough for us to get them down?
I think I'll slow down.
Okay, what's the legal test that this court should apply?
Yes. In deciding whether the UTJ has erred in law
Yeah.
when when deciding to determine the case on the papers.
Yeah.
Issue 3, what are the extent of the reasons which a UTJ is obliged to give when deciding whether to determine an appeal on the papers?
Yeah.
Issue 4 is what is the legal status of the presidential guidance?
Is that that's the PGN, what we've called
Exactly.
the PGN? Yeah.
Which is under consideration in this case. Issue 5 is a related issue to question 4, but you may not need to decide it, but I've set it out anyway. But are the contents of the presidential guidance a relevant consideration which a judge, a UTJ, is obliged to consider when deciding whether to determine an appeal on the papers? Issue 6 is a contentious one in these proceedings. And it's this: what, if any, relevance does the decision of the Administrative Court in JCWI have in deciding in an individual case whether a UTJ committed an error of law in determining a case on the papers?
Yeah.
Issue 7 is having regard to the principles in issues 1 to 6. Was EP Albania correctly decided? I should say that in my submission you can answer, and I will be contending that you can answer issues 1 to 7 without deciding whether JCWI was correctly decided. Just clarify that now. But by way of alternative position, issue 8 is whether JCWI was correctly decided. And then in issue 9, I deal with the facts of these appeals, apply the relevant facts to these appeals.
Right. Well, that's very helpful indeed. Thank you.
I think some of the early, the first few issues can be dealt with relatively briefly. addressing the first, what is the legal test which a UTJ should apply in deciding to determine a case without a hearing? And it is, in my submission, a very simple test indeed. It is whether an oral hearing is required on grounds of fairness. I say that the law in this area is the it's the subject of a very comprehensive and accurate summary by Mr. Justice Sullivan, as he then was, in the case of Ewing, and that is at tab 43 in the authorities bundle.
Could we have the page for that, please?
Yes, it begins on page 1039.
Thank you.
Not a man who'd have been comfortable with remote hearings.
No, I gather that, yes.
I'm sure his judgment is none the worse for that. I see in the head note it says it was only if fairness required it.
Yeah.
Commendably simple sentence.
I realise what's happened. Ewing also appears in the supplementary authorities bundle, and that, I'm afraid, is where I've taken.
Well, don't worry, we can find
Take
it,
it.
or we can go to the supplemental bundle.
It's in paragraph numbers anyway.
Which paragraph do you want?
So, one moment.
Paragraph
Hey,
27.
sorry, I was using my name, so it's my.
It's 27 and following.
So it's paragraph 31.
I mean, rather as I pointed out to Miss Kilroy, this is a product of its age, slightly.
It's old school, isn't it? It's hardly part of the one single court, the tribunals and the courts, is it?
Well, it's before the 2007
Yes.
Act as well, although that was going through Parliament at the time.
I mean, I don't think we'd hear a submission now that what's acceptable in the tribunals isn't acceptable in the courts,
No.
by way of fairness.
I'm so
Well,
sorry.
at least I hope we would.
I'm so sorry to delay. It is not a normal page. It is Just above paragraph 28.
Just about above paragraph 28. So we're looking at Lord Bingham's paragraph 16 from...
Above, top of that page.
Yeah.
This, I say, is the essential statement of principle. At common law, one is entitled to an oral hearing where fairness requires there should be such a hearing. But fairness does not require that there should be an oral hearing in every case.
I just can't find those words. Are they in the quote from Lord Bingham or before?
I'm sorry. It's in paragraph 27.
Oh, it's the fourth.
Paragraph 16 of Lord Bingham's speech. Fairness will not, in many cases, require a hearing to...
Fourth line onwards of 27. Common law,
Yes.
one's entitled to norm.
Yes.
The answer to that question is no. In common law, one is entitled to an oral hearing where fairness requires there should be a hearing, but fairness does not require there should be an oral hearing in every case. There we are. Lovely. That's it. And that's in the mouth of Mr. Justice Sullivan, as he then was, right?
Yeah. And the other passage I would rely upon in this decision is a quotation from Lord Justice Taylor. I think again, as he then was.
It's a little while ago.
Paragraph 29.
That's a quote at 29.
29.
Yeah.
And what he says in that quote, the hearing does not necessarily have to be an oral hearing in all cases. And then I say again in the middle of that passage, there is a helpful reiteration of the general principle about halfway down. Whether an oral hearing is necessary will depend upon the subject matter and circumstances of the particular case and upon the nature of the decision to be made.
And whether there's substantial issues of fact to be resolved.
Exactly. And I say that the case law is clear in establishing that no prescriptive formula can be laid down for determining whether an oral hearing would be fair. Save perhaps that there is a recurrent theme in all of the cases. And my Lord's just identified it in the quotation from Lord Justice Sullivan. That the existence of a factual dispute between the parties will always be a relevant factor.
Well, I mean, it's again dependent on the circumstances, because you can envisage a factual dispute which is simply as to, for example, the proper understanding, not legal understanding, but factual understanding of a series of letters, and which neither side wished to adduce oral evidence about, which would be different from a situation where you have a swearing match.
Yes.
I mean, swearing matches generally it's hard to do without an oral hearing.
That is right. So I would say relevant, but not necessarily determinative.
Yeah.
But Lord Taylor himself says it doesn't. Sometimes the conflict's not central to the issues for determination and would not justify an oral hearing.
Exactly. clearly
But I mean, you
also,
don't. I mean, equally, you don't presumably dispute all the House of Lords and Supreme Court authorities that Miss Kilroy took us to in Section 6 of JCWI. I mean, those are all to be read in this context.
about the value of
The value of oral hearings,
Yes.
the tradition in this country of oral hearings.
So that is correct, but my lord, what I would say with respect in this type of case is that it isn't right to approach the question of fairness on the premise that on one side of the scales of justice you have fundamental rights, and on the other side of the scales of justice you have administrative efficiency. That is, I say, an inaccurate simplification, oversimplification of the position. Because delay in deciding cases necessarily involves a delay in giving effect to a person's fundamental rights.
Sometimes to other people's fundamental rights.
Yes. And I say, with respect, it is extremely easy to see these type of issues, to view them through the prism of those who have not received an oral hearing and then have had their substantive appeals dismissed. But of course there is an invisible cohort of beneficiaries.
And the overriding objective to which much reference is made has other features just apart from the feature of doing justice and being fair, obviously, which is a very important feature, or two very important features. But another feature is doing justice to all court users and tribunal users. And efficiency and delay are all part of that.
Yes.
We have to do the best we can for everybody, not for just one person.
Yes.
Which includes balances and compromises and checks on the system.
Exactly. But I would point. I mean, if it is fair to assume that backlogs equate to delay, which I say it is,
Yeah.
then I say that adversely affects people who may have very compelling reasons for needing their cases to be decided promptly. And that includes people separated from their families. It includes people awaiting determination on important matters.
Well, this is why I balked yesterday at what Miss Kilroy was saying, because whilst it is true that immigration matters are of the greatest concern, not only to the court but also to the people affected, so are family matters and criminal matters and all sorts of other matters.
Yes.
Virtually every matter affects individuals fundamentally and individuals' fundamental rights.
Yes.
And the idea that the court selects one type of case and says this case, in this case, all cases must be heard in one particular way, and in other cases that is not the situation, is not necessarily correct. It may be correct, but it's certainly not axiomatic that it's correct.
My Lord, I would agree, but, and indeed the requirement to act fairly, I think this is dealt with in Mr. Justice Sullivan's judgment with a quote from Wade. It arises from the very fact that the court is deciding rights, or indeed any body discharging a quasi-judicial function. So I say the test is a simple one, but as part of, it's non-prescriptive, but as part of what is fair, the tribunal should also clearly have regard to the overriding objective. They're required to have regard to it under their rules, and the purpose of the overriding objective. So we should give effect to the overriding objective, because the purpose of the overriding objective is to achieve fairness. Issue 2.
Sorry, just before you leave that, you're quite right to say that under the upper tribunal rules, they're required to have regard to the overriding objective. What rule is that? Sorry, it wasn't a trick question. I think Miss Gilroy might be able to help.
It's rule 2.
Thank you very much. Sorry to have interrupted.
I think it may be
Rule 1.
Sure, it may give effect to. So issue 2, which is what is the test which should be applied by this court in deciding whether the upper tribunal has erred in law in determining a case on the papers. I sort of added that as an issue because of, I think, something Ms. Kilroy said yesterday about effectively this court should be making its own decision, or an implication in those terms. And what I say about that is that this court must be satisfied that the procedure adopted by the tribunal, including the decision not to hold an oral hearing, was fair. But that certainly does not equate, and I don't think this was suggested, to be fair, but it certainly does not equate to the court retaking the decision. Nor does it remove a discretion which the UTJ is entitled to exercise in a specific case. And when I refer to discretion, I mean that a fair procedure can frequently permit of more than one outcome. And provided that outcome is fair, in my submission, it's not for this court to interfere. For example, I say there may well be cases where it would be fair both to determine an appeal on the papers and to hold a hearing. Both would be legitimate options open to the tribunal as part of a fair procedure.
Well, I mean, that's obvious in some
Yes.
respects, but only if you're right that a paper hearing is fair,
Yes.
because an oral hearing is accepted as always being fair
Yes.
for this discussion.
So, issue 3 I can deal with very briefly, but I think it just should be covered because it is relevant. It's what are the extent of the reasons which an upper tribunal judge is obliged to give in deciding whether to determine a case on the papers. And that we just return very briefly to our Iran, which is at tab 45, 1106. And its head note 4 deals with it. The decision could not be set aside as an error of law for failure to give adequate reasons unless the adjudicator had failed to identify and record matters which were critical to his decision, so that the tribunal was unable to understand the reasons for the decision. I say that that is uncontroversial, and it is illustrated. I don't ask you to turn them up unless you wish to do so, in the paragraphs referred to in the heading.
So putting it more positively, what is needed is to identify and record matters that are critical to his decision so the decision can be understood.
Oh, yes. Issue 4 is what is the legal status of the presidential guidance which is under consideration in this case. And that, I would ask you to turn up at tab 8, page 31 in the authorities bundle.
So what page?
Page 31
In the authorities bundle.
in the first authorities bundle.
That's. Oh, I see. Yes, I'm sorry. I hadn't realised it was here. Oh, it's not, is it? What are we looking at? The PGN?
Oh,
the Act.
Oh, the Act.
It's
Schedule 4, Para 7.
yes,
What is Schedule 4, Para 7?
of the it's schedule 4 to the to the Tribunals, Courts and Enforcement Act 2007.
So you've got a bit of competition with some trundling barrows outside.
Yeah. So
Schedule 4 to the Tribunals, Courts. Oh, it's the 2007 Act.
yes,
Yeah. Okay.
so this is the statutory provision under which, on my understanding, the guidance is made. And it says, paragraph 7 of Schedule 4, power of a chamber president under the 2007 Act to issue guidance, chamber president of a chamber of the first tier tribunal or the upper tribunal is to make arrangements for the issuing of guidance on changes in law and practice as they relate to the functions allocated to the chamber.
I think this is set out in Mr. Justice Fordham's judgment anyway, isn't it?
It is. So
Slightly odd formulation, really, isn't it? I mean,
It is.
guidance about law. You'd have thought that the law was the law and didn't need guidance about the law. You might need guidance about practice.
yes, it
Changes in the law could be the impact of the change.
my understanding of it is that its purpose, at least in part, is to describe changes to law. But
in
I think
case they didn't notice them.
yes. But the key point I wanted to emphasise is it's not the president's description of those changes which is binding. It's the changes themselves.
Well, is it changes in practice, or is it changes in law and practice? Guidance on practice. Sorry to be a chancery lawyer about it, but
It's, as I understand it, it is a general power to provide guidance on changes which have been effected elsewhere, or changes which have already occurred or are about to occur in the law and matters of practice.
As they relate to the functions. So, for example, when the law was changed to push over to the upper tribunal, immigration and asylum chamber, all the judicial reviews on immigration, save for reserve matters, that was a change in the law that the president had to issue guidance about because it related to the functions, namely that they were all going to sit and hear judicial reviews.
Yes.
So it can encompass law and it can encompass practice.
changes in.
Yeah.
Yes.
Yeah.
But it's what I say its status is it's a non-binding descriptive tool which is available to individual upper tribunal judges in order to assist them in interpreting changes to law and practice.
So you said it's a non-binding descriptive tool, did you
Yeah.
say?
The guidance is,
Yeah.
which is available to upper tribunal judges.
Well, that's putting it too wide. It actually is so far as it relates to the function, and that's what the statute, the provision provides for.
Yes. It's a descriptive tool relating to changes to law and practice insofar as they relate to the functions of the chamber.
So what's the what? So what? If I can be rude.
Well, I say before you come to consider the impact of the JCWI decision, it's first sensible to clarify what the legal status is of the guidance which it was construing.
So do you mean, for example, by contrast to the Housing Act 96, which says in terms you've got to take into account guidance?
Exactly.
I see. Thank you.
My first point is that it's not binding, and in relation to my lady's point, my next is issue 5.
Oh, sorry, did I jump the gun?
Issue 5. You may not need to determine this, but issue 5, in my submission, it's not even a relevant consideration which the judge is obliged to consider. I mean, obliged. Obviously, it's good practice to consider. Failure to consider it may make an error of law more likely because the judge doesn't have the benefit of the guidance in relation to a specific area. But it is not itself an error of law. And to take my lady's point about specific provisions which make clear that guidance must be considered. On my understanding, there is no such provision in the tribunal, asylum and immigration tribunal rules. And that contrasts with various other contexts.
Well, I mean, your real point is that guidance of this kind cannot change the law. The law is the law.
Exactly.
The law says you must have an oral hearing if one is required in the interests of justice and fairness, or whatever you describe it as, from various sources. And if the judge doesn't do that, he should have done. And the court will interfere. The guidance is there to help him, and if he fails to take notice of some stuff that is legally required that was in the guidance, he'll be in trouble. But if not, if he had a fair decision, made a fair decision, then he made a fair decision.
Exactly.
I mean, I know that all sounds slightly simplistic, but actually anything else would be absurd.
Yes. I mean, I would just add to it that these 2 points go to the sort of issue of impact of JCWI and the assertion that it infected all of the decisions on paper hearing. And I'll come to that in a moment, but I say you should take into account the fact that it isn't merely non-binding, in contrast to some instances.
Sorry, JCWI is not non-binding.
Sorry,
the guidance.
The guidance is non-binding. In contrast to some statutory contexts, there isn't even, it appears, an obligation to take it into account.
No, because you say yourself, good practice requires
Good practice.
one to take into account. So I don't think you can just say JCWI wouldn't have had any impact or should not have had any impact on anyone because they didn't have to look at it anyway.
No, it's relevant to the degree.
But the critical underlying point
Yes.
is that guidance as to the law or changes in the law does not change the law.
Really, we've just covered this to a substantial degree. But issue 6 is what any relevance does the decision of the administrative court in JCWI have in deciding whether a UTJ committed an error of law in determining a case on the papers. And my respectful submission is little or no relevance. If the reasons given by the judge demonstrate that they have applied an unlawful presumption in favour of a paper determination, then that will amount to an error of law. Whether it arises from the contents of the presidential guidance or from any other factor. But if the reasons demonstrate...
Don't go too fast. Whether it arises from the presidential guidance or...
any other factor, any other misapprehension as to how the UTJ's powers should be exercised.
But
and I say that if the reasons demonstrate that no unlawful presumption has been applied, then there is no error of law. And in my submission, the next point is an obvious one, but important one. And I say this with respect. It is not Mr. Justice Fordham's construction of the guidance which counts for the purposes of determining whether there was an error of law by a judge in an individual case. The only relevant issue is how that judge construed the guidance and whether he relied upon it such as to apply an unlawful presumption. And I say the only way fairly determining that question is with reference to the reasons of the judge concerned. In my submission, that there is nothing unfair about that proposition. My learned friend's position, I don't accept it, adopting it, one moment. Her position is that judges can, upper tribunal judges can, as I understand it, can reasonably be expected to have adopted the same construction of the guidance as Mr. Forden. Well, if that was true, then why can they not also reasonably be expected to reflect that fact in their reasons? And I say in their reasons, whether expressly or by way of implication. And in my submission, it would simply be unsafe to infer, without regard to the nature and quality of their reasons, that an upper tribunal judge had adopted the same construction of the guidance as Mr. Forden.
Mr. Justice Forden.
Sorry, Mr. Justice Forden. And there are two reasons for that. The first is that on my understanding of the judgment in JCWI, the judge sought to arrive at what he described, I think, as a single objective interpretation of the guidance, or the right objective interpretation of the guidance. But he didn't appear to suggest that it was the only permissible or reasonable interpretation. And I respectfully submit that whatever was said in JCWI, or whatever ultimate conclusion Mr. Justice Forden reached, there is ample scope within the body of the presidential guidance for an upper tribunal judge to interpret it differently. Just perhaps staying with that and turning the guidance up, which is at tab 1.
Tab 1 of
The authorities part. Paragraph 7 there is the express reference to the full terms of the practice direction, the lawful contingent presumption. Paragraph 9 may be open to criticism final sentence in it may be open to criticism on the basis that the President did not add the words in parenthesis, subject to the overriding objective, ECHR rights. But it cannot reliably be inferred that a UTJ would not interpret the practice direction in the correct manner, given that it is set out in express terms in the paragraphs above. And I will return later to particular paragraphs in the guidance. But that is why I say it would be unsafe to assume that UTJs read the guidance in the same way as Mr. Justice Fordham suggested in terms of what he described as the correct interpretation. And I say in terms of impact, as I understand it, the position was that 60% of appeals were determined on the papers. That's the position. Can't, I submit, draw any reliable inference from that fact. It's actually readily explicable with reference to paragraph 4 of the practice direction. In relation to the next issue, which is having regard to the principles I've just set out, really issues 1 to 6 above, was EP correctly decided? Just before addressing that issue, I think it was said by Ms. Kilroy that you shouldn't look at EP because it's not before you. Well, it's not before you in terms of being under appeal in this case, but it is clearly before you in terms of being a relevant decision which you should consider. Because the issue before you, as I understand it, is how to approach cases in which upper tribunal judges have decided to determine appeals on the papers during the currency of the presidential guidance. And specifically whether the JCWI decision should result in a conclusion that they erred in law. Well, those were exactly the issues considered by the tribunal in EP. In terms of the decision in EP, I I say that I have correctly summarised what the tribunal decided in paragraph 27 of my skeleton argument.
Paragraph 27.
Yes.
I think I must have the wrong one. Just hang on a second.
This is submissions on both rather than just GA. The consolidated skeleton.
Yes.
Because you do have three skeletons now. You have GA, the consolidated skeleton, and then the final note on Mr. Hussain.
Yeah, yes.
No criticism, but it just need to know which paragraph 27 you're referring to.
No, I'm grateful.
Yeah, no, I've got to get it. So just.
Mine's dated the 13th of January, if that helps.
No, there should be one the 19th of January.
Oh, well,
No,
there we
it's
are.
the 13th of January. If you look at the back page.
Oh, it says 30th.
This is consolidated skeleton argument addressing both.
Yep.
Yep.
It may be that the other day. Paragraph 27 should read the tribunal was tasked with.
Yes.
But if you look at your final page, under your name is the date.
Yes, for some reason I have the 19th. I don't know.
All right.
Well, I don't know if anyone else does. I don't.
No, mine's
No, I
the
have the
13th.
13th as well.
Yeah. Well, you better just check over lunch to make sure there's no pearls of wisdom that you failed to share with us from the 19th version.
We wouldn't want to have a repeat
It's great.
of Mr. Hussein's case. Yes.
So, I've summarised the principles, and I'm not going to repeat them now, but I am going to pull out, if I may, take you to what I say are a.
So actually, you're not talking about 27 at all. You're talking about 28.
Yes.
Do we need to have up the actual judgment?
Yes, it's at tab 17.
Yeah.
It starts on page 159. But the first passage I'm going to take you to is paragraph 180. Sorry, page 180.
Oh, 180.
180, yes.
Thank you.
Is this?
And it's the before I take you to these passages, I say that they give effect to the principles which I've just described in the issues upon which I've addressed the court. So in terms of the end of paragraph 32, the tribunal says, we consider that such a decision is capable of giving rise to a relevant procedural irregularity for Rule 43 purposes, but only if the Rule 34 decision was in error of law in the sense contemplated in SSHD, i.e. that the consequence of the decision to proceed without a hearing was unlawful as a breach of the requirement to act fairly when determining the error of law appeal. So I say they've applied their mind to the right test. But it also illustrates that with respect, there's nothing in the point that in this particular case, tribunal was exercising a review function because they proceeded on an identical basis as would apply in an appellate jurisdiction, i.e. was asking whether the approach of the UTJ reveals an error of law. Again, I could ask you next to turn to page 187, paragraph 48. Shows the tribunal having regard to the non-binding status of the guidance. And I say that their assessment in that paragraph is correct.
Guidance is no more than that.
Yes,
Sorry, where that which paragraph again?
that's 48, paragraph
Yeah.
48.
Thank you.
Next paragraph I would ask you to look at is page 189, paragraph 51. They concentrate, I say correctly, on the assessment of the reasons given. Second sentence in that paragraph.
And the need to consider the overriding objective does not prove such matters have been left out of account. Reference to the practice guidance note. Reasons must be considered in the round.
Perhaps I'll just make this observation about paragraph 53, the final sentence. Given the status of the guidance note, there was no obligation to apply it. And given the principle of judicial independence, the suggestion that disavowal might be required is artificial. In my submission, that's an important point. In terms of emphasising the fact that judges, as independent judicial office holders, are required to apply the law and not take instruction as to the application of the law from one of their more senior colleagues, which is given in an administrative capacity. And that is important to the principle, in my submission, of judicial independence. So I respectfully submit that EP was correctly decided.
Well, correctly decided as to the general propositions. We obviously can't say in the individual cases, as Ms. Kilroy points out, we don't even have the decisions that were made in the individual cases.
And indeed, the Secretary of State has conceded that on an application of those principles, simple principles, the upper tribunal judge in one of these appeals, GA, made an error of law because there is no consideration in her determination of the fairness proceeding without an oral hearing. If I could move now to the next issue, which is whether JCWI was correctly decided. Perhaps first addressing, do you need to resolve that at all? I think the answer is no, you don't on the preceding analysis which I set out.
But exactly, if your previous analysis is right, then Mr. Justice Fordham's decision is very interesting.
Yes.
Out of no relevance to the determination of this case.
Yes. But by way of an alternative position, I submit that it was wrongly decided. I've set that out in detail in my skeleton argument. Set out the basis for that in paragraphs 31 onwards of my skeleton argument, which I will return to, although I'll try not to repeat. But Ms. Kilroy relied upon the case of Gillick as saying that JCWI, I think, was correctly decided. And so, in my submission, that case should be looked at.
That's if we're actually going to get into deciding this point.
Exactly.
But I mean, it's recognised that if we do get into deciding this point, then we're going to have to have further time, at least, for the appellants to respond and other aspects of it.
Yes.
I mean, are you positively inviting us to do that now, given your other submission? Or you've laid the ground. If it's not necessary for us to decide it, it's not decided, and no doubt the Secretary of State might, given, as Mr. Kilroy points out, there are numerous other cases coming our way, be entitled to argue it in future cases.
Yes, I think the answer is, as by way of an alternative position, I am inviting you to decide it based upon the arguments set out in the skeleton argument, which perhaps I won't repeat, but I do continue to rely upon. But I do submit that even if you decide not to resolve the question, there is clearly an issue to be decided at some stage as to the correctness of the JCWI decision, not least because of the clarification of the law which postdated it in re. So I do respectfully submit that at the very least it would be appropriate highlight that fact that there is there will be a necessity to consider it.
Well, that depends, because if it's common ground, which it appears to be, that actually what you're looking at is were the proceedings in front of the tribunal, upper tribunal, fair?
Yeah.
Whatever Mr. Justice Fordham had said about the possibility or probability of the guidance note leading to unfairness is a matter of history. What everyone needs to concentrate is on whether the proceedings are fair, in which case no one's ever going to need to get into whether he's right about the overall paper norm or the contingent paper norm, which is what divided the parties below him.
That is right, but I understood my learned friend to still be contending that the JCWI decision should be deemed to have an operative effect, regardless of...
Well, she's asked us to say expressly that JCWI is correct. You have asked us to say it's wrong, but maybe you're both wrong, and we don't have to say whether it's right or wrong for the reasons my lord just gave.
Yeah. That may well be right, and I've accepted that may well be right. I mean, what I would ask to do is address you very briefly in relation to point arising from Gillick, and then to rely essentially upon what I say in my skeleton argument.
Well, I mean, the most useful thing for you to do initially is to make any further submissions you want to make on why we should decide the question of whether it is right or wrong. Right? Now, at that point, I mean, I'm perfectly prepared to hear your submissions on why it's wrong, Debeni essay,
Yeah.
and then at some point tell Miss Kilroy whether we're going to decide whether it's right or wrong or not. But
Yes.
I would have thought the easiest way is for you to tell us why you say we should decide whether it's right or wrong. Positive.
Two reasons.
Right.
2 reasons. Reason number 1 is what I understand Miss Kilroy's position to be, which is that the guidance infects all of these decisions.
If you're right, it doesn't.
Yeah. But if you were to be with her on that
Right.
suggestion, you would need to consider JCWI.
I see that.
Reason number 2 is that JCWI raises an issue of wider public importance, which is the test for determining whether judicial guidance is lawful. That is clearly an important issue, which in my submission needs to be resolved at some stage.
Sorry, whether judicial guidance is lawful.
Yeah, the test for determining whether, presidential guidance is lawful.
I mean, I'm just slightly wondering why you didn't appeal JCWI.
Well, the Secretary of State, I don't think was a party to JCWI.
No, but the government legal department were.
They were. The government legal department, I imagine, acted for
Yes.
the president. So,
Well, he was hardly going to go into court to defend himself.
so I don't know.
No, I thought you'd say that.
But I wouldn't be entitled to know.
And to be fair,
Chinese walls in Ethiopia.
and to be fair, you, as you made clear in the directions hearings, you were only instructed in sort of December time.
And you might also perfectly properly say it's a question that overreaches privilege.
Yes.
It would not be something I'm entitled to ask, so I don't ask you.
I don't think the section.
But having not appealed it, it does make it more difficult for you to say that in another case where it possibly on one analysis is not relevant to what we have to decide should nonetheless be overruled.
Well, I mean, I would rely on the fact that the Secretary of State wasn't a party. She could have been, it seems, but she wasn't. So there was no opportunity
No, that's fair enough.
for her to appeal. And I respectfully submit that we may be in the realms of speculation as when deciding why the president didn't appeal. I mean, I don't know, for example, whether he concluded that an appeal would be pointless because the position was going to change. I just don't know.
Okay, well, I mean, how long are your submissions now going to take on Gillick and why we should actually overrule JC?
I hope I can deal with that before lunch, and then briefly.
So you want to take half an hour on that? I think we'll just rise then for a couple of minutes.
All right. Just to inform you, the live streaming will be running because it's just for a few minutes.
And it sounds right. Never proves. Okay, read it.
Council, are we ready? They're coming in. Yeah. They're literally just finishing up. Council, are we ready? Court rise.
So, Mr. Waite, the present position is that our provisional view, subject to taking time, is that we do not think it will be necessary to decide these appeals, to decide the correctness of JCWI. But if we change our minds, and we reserve our right to change our minds on that, we will let you know and hear further argument before making up our minds. So that, I think, does abrogate the need for detailed argument on why JCWI is wrong, but you may rest assured that we have in mind your submissions in writing and know what you say.
My lord, thank you. In that case, I will move to the final issue, which is addressing the specific facts of these appeals. And if I could start, please, with the case of Hussain. And the sort of introductory point I want to make about Hussain before addressing what I say should happen in the case is that it reinforces the undesirability of proceeding on the basis that upper tribunal judges have adopted the same construction of the presidential guidance as Mr. Justice Fordham. The reason is, if you go to page 49 of the bundle,
Sorry, which page? 49 of which bundle?
49, I'll have a look.
49 of the core bundle or some other bundle?
The Hussain bundle, I think.
Hussain,
sorry, Hussain,
it's the judgment,
Okay,
or
I've
the
got it.
decision, I should say.
Sorry, I've gone to the wrong. Yes, sorry, it is. I think it is.
49 Annex A.
annex.
It is Annex A.
Yeah.
What there is. Sorry, I was using the electronic bundle. Yes. 49. There's the reference to the ILPA letter in paragraph 3. And the UTJ refers to the appellant's reliance upon the ILPA letter dated the 2nd of April 2020. He says what the appellant did not do was provide, in addition to the ILPA letter, a copy of the reply by the President of the Upper Tribunal indicating no arguable merit in the submissions of ILPA. And what that reply does by the President is emphasise, and it's at page, I think, 174 of the bundle in Hussain.
174.
174. What it does at paragraph 5 is emphasising unequivocal terms the existence of what has been described as the lawful contingent norm in the practice direction. you'll see that from the fact that the word provided is underlined.
Yes.
Certainly this judge has had regard to that letter in reaching his decision. In terms of the facts of Hussain, could I first of all address the point, that the suggestion that submissions were overlooked. I accept that the evidence is in an unsatisfactory state, and I accept that it would have been better for the upper tribunal judge. Sorry, when I say the evidence is an unsatisfactory state, I mean the evidence as to what was filed and when is in an unsatisfactory state. And it would have been better if the judge had made clear that he had expressed regard to the 2nd of April submissions. What I say about that is twofold. Firstly, the 2nd of April submissions add nothing to the subsequent submissions which were submitted by on behalf of Mr. Hussain on the 9th of April 2020 and the 16th of April 2020. The 9th of April submissions related to the issue of an oral hearing, and the 16th of April submissions related to the substantive merits of the appeal. And I say that actually in each instance they are a more detailed version of what was put on the 2nd of April 2020.
But I mean, it remains the case that you couldn't have studied this case without realising something was missing.
Well, I say that you should not draw the inference that the judge failed to have regard to the 2nd of April submissions. I base that.
Well, I mean, what do you say about the point I just made? I mean, oh, I see. You say he did have regard to the 2nd of April submissions.
I say that is the inference, because
Well, how?
It doesn't
I'm sorry, I just don't see that.
No.
well, I say you put two factors together. First of all, the point is raised in the application for permission to appeal before him, and he says, "I had regard to all."
But we looked at that yesterday,
And
there was no basis upon it. There didn't seem to be any time when he did get those.
well,
I mean, when he said, didn't he say that
Well,
paragraph
not-
6, the chronology,
Yeah.
you know,
Not only-
subsequently he was brought up to date, and there's absolutely no evidence.
Not only does he, there seems to be no basis for saying that he did have regard to them. There seems to be a positive basis for saying he didn't.
Yeah.
I mean, he makes positive statements that are inconsistent with his having seen them.
well,
I agree there's then the ambiguous final denouement in the in his answer to the complaint, in the permission to appeal. But before that, as my lady says, we went through it with a tooth comb yesterday with Mr. Lee, and speaking only for myself, it seemed pretty clear he hadn't had them.
The Annex A, 18th of May, page 50, he said what he says is in terms that he's not seen them because he denies they exist. So, which was why I asked the question about whether between the 1st of May and the 3rd of August there'd be anyone had done anything to draw them to his attention, and the answer was no, there hadn't. So I need a lot more to say that for myself that I should draw the inference wholly contrary to that. You'd seen them and taken them into account.
I mean, the first communication from the appellant was not received until the 9th of April 2020, which, rather than dealing with the specific terms of the direction, applied for an adjournment, claiming the hearing should be stayed for face-to-face. Now, that's absolutely clearly wrong.
I accept that as of the time of the directions,
He couldn't have seen it then.
couldn't have seen it.
But the difficulty is he then puts the directions as part of his decision. It would have been perhaps a different point if he hadn't annexed them, but he didn't put them there and say, oh, by the way, there's this immaterial error because I've now seen them. And it goes a bit to the authorities on fairness. I mean, one of the reasons for having an oral hearing, there are lots of other reasons, but one of the reasons is so that people feel they've had a fair crack at the whip. And this litigant has lost with the judge saying what he did was procedurally unfair, when in fact we know he'd sent it in. I mean, if I was the litigant, I would feel a burning sense of grievance. Now, that may be a reasonable or unreasonable reaction, but how do you deal with the issue of fairness, given that he appended those directions to his decision?
I read it in this way, that he had confirmed that he had read the 2nd of April submissions, because if you go to page 22 in the bundle, you'll see this.
Core bundle.
Sorry, core bundle. So the page 22.
Yeah.
You've got this clear assertion that he failed to take account of the 2nd of April submissions, and the respondent had confirmed that they had been filed and served in time.
So that we then have to immediately look at the decision of the 27th of May, paragraph 2.
Yes.
Response received not in the terms anticipated directions. Accordingly, further directions were issued and sent to the parties, a copy of which set out Annex A. Annex A said, I haven't had them, they didn't exist.
Annex A did say that, and he clearly should have corrected that. But if we look at his response to that ground of appeal on page 31, ground 2 asserts that the upper tribunal committed a procedure error by failing to consider correspondence from the parties, but such claim has no arguable merit. It was not a requirement to set out each and every aspect of the evidence, but all pleadings and available material was properly considered by the upper tribunal. And I say that you should draw the inference from that, and indeed some other matters which I'll take you to shortly, that whatever he said when he wrote the initial directions, he had in fact retrieved the 2nd of April submissions, because that is the implication of what he says, I say, in subparagraph 6, that he had in fact considered this material.
Well, probably is, but it's also inconsistent with the contemporaneous evidence. I mean,
Well,
why it happened is there's all sorts of possible explanations for it. I mean, I put to Mr. Lee yesterday as to whether he was saying it was in some way dishonest or inappropriate. But there's all sorts of other explanations. I mean, he could have forgotten, he could have not quite understood, he could have not read it properly. I mean, there's all sorts of things that could have happened. But we've got to deal with what we know. And what we know is that on any proper analysis of what he wrote at the time, he hadn't seen them. and there we are.
I don't, with respect, I don't accept that on any proper analysis of his substantive determination and not the annex, he hadn't seen them. Because...
Would you say he put the annex in without reading it?
Without
it's possible.
Seemingly, if you put the annex together with the refusal of leave to appeal and the contents of the submissions of the 16th of April.
But he put the annex to support as what he was saying in paragraph 2, that he hadn't had a submissions. And then we look at paragraph 6 that you've just taken us to. The chronology was clarified at a later stage, and there is no evidence whatsoever, and inquiries have been made overnight, that anything happened between the 27th of May and the 3rd of August to clarify the chronology leading to all submissions, which clearly, to my mind, suggests that something had happened which made him go, oops, I've not seen those, I'll now read them and take them into account. And on any view, that can only have been after the decision in any event.
You mean take them account after the actual determination?
Yeah.
Because you see, if you look at page 35,
Absolutely.
which is the ground 2 of the document, where this point is made in the permission to appeal to the Court of Appeal, what that refers to in brackets is C Annex A and para 2 of the determination, etc. And then it refers to the email of the 15th of May and other emails and say this correspondence is enclosed. Well, we haven't got it, but one infers then that it was enclosed, and therefore the judge read it and wrongly assumed he'd seen it at the time, or that it had been clarified before.
I mean, the mystery in this respect, if you look, it gets more confusing, but if you look at the submissions of the 16th of April,
Yeah.
which start on page 51. What you'll see in that document is these are the submissions of the Appellants Council of the 16th of April, which were clearly read in detail.
Yeah.
You can tell that. And what they do is persistently refer to get submissions, or in a number of places, submissions of the 18th of March. So it gets more confusing now, but you go to, for example, to the bottom of page 53, you'll see an example, 18th of March there. Now, and again, paragraph 21. Now, what the Appellants Council means when he says the 18th of March submissions is in fact the 2nd of April submissions.
Yep.
And you can see that if you cross-reference. So it would be very surprising indeed if an upper tribunal judge, faced with another example, paragraph 24, numerous references to what are in fact the 2nd of March 20 submissions, just ignored them when he came to write his determination.
But he did, he says he did, because he says he never had them.
In the annex, correct, but I say...
And in paragraph 2.
But even if you're right, Mr. Wade, this is not a situation where one can sort of say, well, he may have seen them, he may not have seen them, it's not clear, there's no evidence, and therefore we should dismiss the appeal. It's precisely the reverse situation, where justice must not only be done, but be seen to be done, and it's not clear. There may be lots of explanations we don't know, but the poor old appellant is entitled to have a proper hearing on the basis of his submissions. I mean, you can't say, well, there's doubt about the construction of it and therefore you should dismiss the appeal. That would be a denial of justice.
Well, I would accept that, but for one point which arises in this particular case. And I say, if you look at them, the submissions of the 9th of April 2020 and the 16th of April 2020 are simply a more detailed version of what was put in.
Well, Mr. Waite Mr. Lee has taken us meticulously to various aspects of it which are only found in that submission. And as my lord says, that may be a technical lawyer's construction, that there isn't much in the 2nd of April, but that doesn't deal with the apprehension of justice and the need for justice to be seen to be done. I mean, if, these courts operate on the basis that we actually pay attention to what people submit to us, and whatever type of hearing is involved, the same principles apply. And you can't just say, oh, well, it doesn't really matter, because it does really matter, because the whole purpose is that even if people don't like the decisions that are made by judges, they have to be confident that the judges have taken account of their contentions.
And I say you can be confident of that, because...
Well, I mean, my lady doesn't seem very confident in what she said.
Yes, well,
And
I'm not.
we're not saying that her view is irrational, are we?
But your submission as to why we should be confident.
Yeah, submission as to why you should be confident.
Yeah.
Just very briefly. First of all, on the oral hearing, compare and contrast with what is said in relation to that point on pages 73 and 74. A very brief submission. With the much more detailed submission, which is not in dispute, the tribunal judge considered, which start at page 62 and go right through to 65. It is an immeasurably more detailed statement of the appellant's case.
That might have been, I mean, plainly, if you put in a 2nd of April and then you include them in a consolidated skeleton afterwards, whether you've had it or not may not matter. But it does matter. How do you deal with the point where the judge actually specifically records it's procedurally unfair? It rather suggests the judge is slightly irritated by this appellant playing fast and loose with the rules.
That may be so, but I
Which is reflected also, sorry to interrupt, but just this, when you raised the point on Annex A, the judge's irritation, I felt, certainly for my part, was also reflected in his dealing with the ILPA letter at paragraph 3. What the appellant did not do was provide, in addition to the ILPA letter, the reply. I mean, there is a general air of judicial irritation.
Maybe right, but I don't think that would have that irritation would have stopped him fairly examining the content of the submissions.
Well, Mr. Waite, why don't we give you the lunchtime to reflect on this? How long do you expect to be after lunch?
I hope perhaps 40 minutes.
40 minutes.
40.
That gives us plenty of time. Very good. 2 o'clock.
All rise.